Welcome to Roman Manor. This lesson will explore a basic element of a criminal offense, specifically the element of Actus Reus, under both the common law and the model penal code. A word of caution, this course is intended to answer academic questions only. These materials are intended to reinforce your legal education or to satisfy the curious layperson, not legal advice. And with that, let's get to it. This lesson's purpose is to give an in-depth look at the element of Actus Reus to better understand the specifics of the criminal offenses covered in other videos. This lesson will proceed as follows. We start with a lesson introduction before examining Actus Reus in depth, as both the common law and MPC understand the concept before concluding. Actus Reus is the first of the basic elements comprising any crime. Without the Actus Reus, there is no crime to define. Of course, an Actus Reus is necessary but not sufficient without the other elements of mens rea, concurrence, and causation. But we here will focus on the guilty act before examining those others. So how is Actus Reus defined? Actus Reus refers to a physical act or unlawful omission constituting the criminal offense. Black's Law defines Actus Reus as, quote, Latin for guilty act, the wrongful deed that comprises the physical components of a crime, and that generally must be coupled with mens rea to establish criminal liability, a forbidden act, unquote. What constitutes an Actus Reus will vary according to the criminal offense. A homicide will require an act resulting in the killing of another human being. An arson will require an act resulting in the burning of a habitation, and so on. The common law divides the Actus Reus element into 1. A voluntary or intentional act, including possession, or 2. An omission to act. But the viewer must also note that there is no singular authority regarding the common law. It is the product of judge-made law, interpreting state statutes at various points in time and space, which is to say history. Under the common law, culpability requires the defendant to have intentionally engaged in a physical act of some sort. Mere thought without more is insufficient to qualify as a voluntary act. Black's Law defines an intentional act as, quote, an act resulting from the actor's will, directed to that end. An act is intentional when it is foreseen and desired by the doer, and this foresight and desire resulted in the act through the operation of the will, unquote. This is not a terribly complicated concept. Simply put, the actor must have consciously intended the action he engaged in. For example, if A pushed B, causing B to bump into C, and C then fell into the street and was struck by a car driven by D, B is not responsible for C's harm. Arguably, it is A, via transferred intent, or the driver, D, through negligence. B is not responsible because he did not intend, either consciously or through his own will, to push C into the street. Similarly, if, while walking, A collapsed on the sidewalk with a seizure and struck B in the face during the episode, A is not culpable to B for that contact. He was not in control of his body at the time of the seizure. This example should serve to reinforce the notion that the act comprising the Actus Reus must be done intentionally or voluntarily to another. An omission is the intentional absence of an act otherwise required of the actor. Black's Law gives a more full description of what the common law definition of the concept entails. It provides that an omission is, quote, a failure to do something, especially a neglect of duty, the act of leaving something out, the state of having been left out or of not having been done, something that is left out, left undone, or otherwise neglected. To sum it up, an omission is the recognition of a required act's absence. If these definitions seem fuzzy, it's because they are. Under the common law, the definition of Actus Reus, or any term for that matter, will vary because that is the nature of the common law. Judges have wide leeway to interpret the law, and their decisions, over time, have produced a wide variety of outcomes, to say nothing of definitions. So let's take a look at a cleaner, more thoughtful, and better organized model of legal thinking, the Model Penal Code. The MPC sought to clean up the messiness of the common law by codifying its salient aspects into a model code. Under the MPC, Actus Reus is divided into three categories: 1. Voluntary acts, 2. Omissions, and 3. Possession. We'll start by looking at the MPC's definition of Actus Reus before examining how it defines each of those three categories. Actus Reus is codified in Section 2.01 of the MPC. It begins with the statement that a person is not guilty of an offense unless his liability is based on conduct that includes a voluntary act or the omission to perform an act of which he is physically capable. The Code's commentary on this section calls this statement, quote, the fundamental predicate for all criminal liability. It requires the defendant's guilt be based upon conduct, which must include a voluntary act or omission to perform an act of which he was physically capable. What we can take from this is that, as we see in the common law, a criminal act must include conduct of some type and not mere thought. Thought without action is insufficient for criminal liability to attach. We do not yet have thought crime in the United States. The MPC does not expressly define what a voluntary act is. Instead, it highlights what a voluntary act is not. Section 2.01, subsection 2 states that, quote, the following are not voluntary acts within the meaning of this section. A reflex or convulsion. B, a bodily movement during unconsciousness or sleep. C, conduct during hypnosis or resulting from hypnotic suggestion. D, a bodily movement that otherwise is not a product of the effort or determination of the actor, either conscious or habitual. What is made clear in this subsection is that a voluntary act must be the product of an intentional or voluntary movement made consciously by the actor. Now let's move on to the second Actus Reus category. The default position of the MPC is that liability cannot attach from an omission unless A, the omission is expressly made sufficient by the law defining the offense, or B, a duty to perform the omitted act is otherwise imposed by law. Of course, for an omission to occur, there must first exist a duty to perform. An example of subsection A is the express duty of every adult American who earned income to file income taxes per the relevant statute of the Internal Revenue Code. An example of subsection B is the duty, first expressed in the common law and now codified in every state, that a parent owes a basic duty of care to their infant children. Under the MPC, failing to perform the acts constituting either example is an omission sufficient for liability to attach. Let's move on to the last Actus Reus category under the MPC. Unlike the common law, the MPC carved possession out of the category of voluntary act and made it a separate Actus Reus category. Regarding possession, the Code states that possession is an act if the possessor knowingly procured or received the thing possessed, or was aware of his control thereof for a sufficient period of time to have been able to terminate his possession. Under the common law, to possess something otherwise prohibited by the law constituted a voluntary act. By contrast, the MPC recognized this circumstance as a distinct type of Actus Reus. The Code's commentary to Section 2.01, subsection 4, provides that possession can occur in two instances. 1, by voluntarily acting to possess the thing forbidden, or 2, by omission. Regarding the first instance, the commentary states that, quote, if the actor knowingly procured or received the thing possessed, his conduct will have included a voluntary act, and liability can be imposed consistent with the Model Penal Code. The commentaries continue regarding omission, stating that, quote, if the actor was aware of his control for a sufficient period to have been able to terminate his possession, his conduct will have included an omission to perform an act of which he was physically capable. That omission is sufficient for culpability to attach to the actor. Okay, So we've covered the Actus Reus element as understood under both the common law and the MPC. This lesson's purpose was to provide an in-depth look at Actus Reus to enable a better understanding of the specifics of the criminal offenses covered in other videos. We started with a lesson introduction before examining Actus Reus in depth from both a common law and MPC perspective. We saw that the common law categorizes Actus Reus into two categories. One, a voluntary act, which includes possession, and two, an omission. In contrast, the MPC divides the element into three categories. One, a voluntary act, two, an omission, and three, possession. Take a look at the other videos in this playlist regarding mens rea and causation to round out your understanding of the basic elements of a criminal offense. That's it for this lesson. If you found it helpful, give the video a like and subscribe to the channel. Leave some comments below and check back often for more content. As always, thank you for visiting Roman Manor and have a lovely day.